I'm Kelly Roberti, an Associate Financial Advisor here at Sensible Financial, and I will be your moderator. Today, Sensible Financial's Frank Napolitano will talk about digital assets and how they play a role in your estate plan. Frank is a CFA charter holder and holds a bachelor's degree from Harvard University and a JD in Business and Financial Law from Boston University School of Law. You can see all of our past webinars and register for upcoming webinars on Sensible Financial's website at sensiblefinancial.com/webinars. Please submit your questions through the Q&A link at the bottom of your window. Frank will answer as many questions as he has time for at the end of the presentation. Unfortunately, he cannot give personal advice in this setting. There isn't time to gather the information and context necessary to do so. We will display Frank's contact information at the conclusion of the webinar. Now, Frank will begin.
Good morning or good afternoon, everyone. My name is Frank Napolitano. I'm a senior financial advisor here at Sensible Financial Planning. And today's webinar is on digital assets and your estate plan. I've been sort of giving webinars on the topic of estate planning for about a year now. So I encourage you to look at some of those old webinars. I think there's a lot of overlap here. But today we'll sort of specifically be focusing on digital assets. And so in this webinar, I'm going to try to accomplish four things. We're going to sort of define what we mean by digital assets. We're going to, or I'm going to try to convince you why planning for these assets is very important. I'm going to explain sort of where the digital estate plan fits into the traditional estate plan. And then I'm going to go through sort of a four-step process for how to get started to organize and start sort of preparing that digital estate plan. And let me just say here at the beginning, that the best route is working with an estate planning attorney. So ideally, you have an estate plan, you can go to that estate planning attorney, and if you don't have any language in your estate planning documents so far about the management of your digital assets, make sure you update that plan. The four-step process I'm going to talk about here will be most useful, I think, for those of you who've not done any estate planning, or perhaps you haven't done this aspect of the estate planning process. And I think that the steps I have in here are going to be useful to sort of prepare you for meeting with the estate planning attorney. So, let me start here at the beginning by saying something obvious, right? That digitization has radically changed the way that we own assets. And I have a few examples here I think everybody will be familiar with. So music in the past, we used to own hard copies of recordings in the form of vinyl. When I was in high school, it was CDs. Today, if we own music, it is in zeros and ones, right? You may have some holdovers. I know we have a small vinyl collection at home because it's fun. It's a novelty, but really almost all digital music today, certainly all music that's being purchased, is being purchased in the form of digital music, either something you own on a personal device, a personal hard drive, or something that's saved out in the cloud, like a music subscription service. Digitization has changed the way we communicate with each other. So letters in the past used to be, in fact, letters, paper and pen, envelopes and stamps. And even though I still receive a few of these every year, my grandma likes to write sort of end of the year summary letter to everybody in the family. Most communication today is in the form of electronic mail. Perhaps you use Google, perhaps you use Apple or Yahoo. If you have these services, as I've had, I think, since the mid-90s, you could have tens of thousands, maybe hundreds of thousands of electronic communications in among your services. And one final example, the way that we record our memories, our treasured memories. There used to be these things called photo albums. Your parents or grandparents may still have these things. I remember as a kid, we'd hop in the car, drive down to Florida. My father would have a big VHS camcorder as well as a camera. And when we were done, we came back, we develop the film and put them into books, and that's how we remembered what we did. Today, everything is online, essentially. I'm using Instagram just as an example, but if you have Apple and you live in their ecosystem, you have photos and videos saved to the Apple iCloud. If you have Google Photos, right? At this point, you may have years and years and years of memories saved to these services. And so, although the means by which we record and save these memories has changed really dramatically in the last several years, those memories are just as important as they ever were. So if you're concerned about preserving those memories, then we have to plan on sharing or transferring those digital assets as part of a holistic state plan. So let's get to, we've sort of covered a couple examples of digital assets here, but let's define what we mean by digital assets. And I'm going to use as a source here the 2015 Revised Uniform Fiduciary Access to Digital Assets Act. Because we don't have enough time today for me to say this a dozen times, I'm going to call it the RUFADA from here on in, but understand that's what I mean, this large acronym. The RUFADA is a useful starting point because it is a model law. It's not a federal law, but it's a model law that many states have adopted, and in part or in whole. And so it has a lot of influence in this area of law, digital assets. Now let's break the definition into two pieces, because I think people get confused by the second part. So digital asset means an electronic record in which an individual has a right or interest. Very broad-based definition. This can mean really just about anything that an individual can access through a computer, through a smartphone, a tablet, or an e-reader. So very broad-based definition of what we mean by a digital asset. The second part of this definition, okay, quote, the term does not include an underlying asset or liability unless the asset or liability is itself an electronic record. What are they trying to accomplish with this definition? They're trying to distinguish between the digital asset, which is, let's say, the login information to your electronic bank account, your Bank of America, it's your username and password. That is the record in which you have an interest or a right. Trying to distinguish that digital asset from the money in the account, right? And so this excludes the traditional assets or property law or types of tangible property, which is covered by, let's say, traditional property law, right? What does it include? So an asset or liability where the asset or liability is itself an electronic record. We're talking about things that are digital assets with monetary value. And so I have two examples here. One is Bitcoin, or we can think about cryptocurrencies more broadly, right? So where the access token lets you access this record, and the record is itself an asset. It's a Bitcoin. It's some sort of cryptocurrency. And the other example I have here, people may not remember this already. This was a bit of a fad a few years ago. This is a non-fungible token, an NFT, and this is a Bored Ape. This is something that had a lot more value, admittedly, a few years ago, but still has some monetary value today. So we can think about digital assets as sort of on a spectrum of assets that have, let's say almost purely sentimental value. If you think back to, our email accounts or social media profiles, that's a big one. Digital media, I've mentioned this earlier, so photos, videos, music, etc. All the way down to include assets that have some monetary value, so cryptocurrency, self-type currency, rewards programs, frequent flyer miles. These would be digital assets, right? Where the underlying is itself an asset, and non-fungible tokens. All right, so with that, digital assets encompass a broad array of assets, and undoubtedly everybody on this webinar today owns digital assets. So why do we care about these things? Why do we care about planning for digital assets? I'm going to try to convince you 3 reasons why I think planning for digital assets is important. So digital assets really create some unique estate planning issues. Take the first example. When someone passes away, their executor, so the executor is responsible for property that passes through a will, or their trustee, the trustee is responsible for property that passes through a trust. One of the first things they must do when somebody passes away is make an inventory of the decedent's assets. This is hard enough already. So for tangible property, in someone's home, they may have file folders, they may have boxes, right? If they haven't written down their assets in a easy to go to place, my previous webinar on letter of instructions that covers this in detail, it is possible to put together the balance sheet. Time consuming and frustrating, but it can be done with tangible property. What is the problem with digital assets? There's often no paper trail. So if a loved one had a Dropbox account or a photo collection at Google or an email account at Apple, you may not be even aware of the existence of that digital asset unless they've written it down somewhere. So there's the issue of identification. What are the digital assets that somebody owns or has an interest in? There's a second problem, which is digital assets are often harder to access than traditional assets. The strategies that we adopt, that we put into place to prevent criminals from accessing your data, right? The safeguards we have there, also make managing digital assets themselves harder for everyone. Cybercrime is a serious problem. I have some of the statistics here, and it's probable that you know somebody whose identity has been hacked, whose email account or social media, Facebook account has been hacked, or is that a credit card information stolen? And so we know we have to put steps in place here to protect ourselves, to protect our digital assets. If our digital assets were a bicycle, this would be the safest bicycle on the block, right? But it's not very practical. If something is that locked down, then neither you or the people you would trust to use your bike could use it. So the very measures that we have here, so strong, unique passwords for each online account, multi-factor authentication. So this is simply another way of authenticating yourself, often with a push notification to a phone or a physical token. These things are necessary to protect our privacy, to protect our assets, but they also make it difficult for someone else who you may want to give access to these assets to, in fact, access them. And the third issue is really interesting. Digital assets present some really interesting legal issues. And I'll be honest, before I was researching this topic and sort of putting together this webinar, I didn't know much about law around digital assets. So this was sort of news to me, and it really is kind of the new frontier of estate planning. So if you have an estate plan and it does not include instructions for digital assets, that wouldn't surprise me. I've not seen many estate plans with this because it is so new. So let me sort of go back to the RUFADA, talked about this earlier, right? And sort of talk about what this model law is. So it's a law that provides fiduciaries here with a legal path to manage digital assets of a deceased or incapacitated individual. It's a really important law. It's the first time that property rights, traditional property rights, have been extended to include digital assets, right? So this is a sea change. The scope of this is also very important. So most states today have adopted the RUFADA in some form. Again, it's a model law. The states look to it for guidance, and they pick and choose the pieces that are useful. So for example, what constitutes a fiduciary under the Act is an agent under a power of attorney, an executor, a trustee, and a conservator appointed by a court. That definition will change among the states. And so, again, going back to the importance of having an estate planning attorney who understands digital assets and the laws in your state is essential here. A couple other things to say about the RFADA before moving on. It creates a three-tier process of access, and many states have adopted this access tier. So the first step is to determine whether the user here has subscribed to a digital tool for one of their custodians' digital assets. So an example here would be Facebook. Facebook has what's known as a memorialization feature, and you can choose in advance what you want to happen with that digital asset, your social media profile, after you are gone. You could choose to delete the entire profile, right? You can also choose to memorialize it. So your page and your history would continue to exist on Facebook in some form. There's some options there. But you can choose in advance and be very clear about the disposition of that asset after you are gone by using this digital tool. And that digital tool will supersede any other instruction. So that's tier one. The second tier, the second place to look is, has the person put down any instructions in their legal documents? Have they left instructions in a will or in a trust or in a power of attorney? And if so, those rules will apply to the extent allowed by law. Third is, what are the provider's terms of service? So here, if you do not think you have an estate plan that covers your digital assets, you do. And in fact, Facebook has a plan for your digital assets. Apple has a plan for your digital assets. Google does. And any provider whose services you're using. Also, in preparation for this webinar, I thought it'd be interesting just to pull up a portion of Apple's terms of service here. My attempt at humor, page 1 of a bazillion, right? And I went to find the section under rights of survivorship. If any of you on this webinar have ever had an Apple product or ID, then you've agreed to this. And this rule lays out what happens upon the owner's death. So accept is allowed under digital legacy. This is Apple's digital tool. And unless otherwise required by law, you agree that your account is non-transferable and essentially dies with you. The data will be erased upon your death. And so if you have assets at Apple and your wishes differ from these terms of service, you have to be thinking about how to plan for those assets. One final example, I thought it'd be interesting to go to Google to try to figure out, well, what would happen if a loved one passed away and their photos are there, and I was trying to get access to those photos. There is a process here. There's a section on their website where you can request to obtain data from the deceased user's account. And part of that process is agreeing to Google's terms of service here, is to obtain a court order issued in the United States. So it's possible to not have anything written down in an estate planning document. It's possible not to have used one of these digital tools to transfer or delete your data and to go through a legal process here. But it will save your loved ones time and money by planning on these assets in advance, right? And there's also no guarantee that with a court order, somebody would be able to get access to photo collection or an email account or a calendar or something like that. Okay. And one final note about instructions in someone's legal documents. I was surprised by this. I thought simply you could transfer property in a will like you would tangible property. You know, I leave my book collection to my sister or something like that. Not so. That information is subject to the laws of the state in which you live, and providers can limit access to, quote, reasonably essential information for settling an estate. So there's a lot of ways to make a mistake in your estate planning by not knowing the assets that you own, the digital tools that are available, the laws within your own state. All of this argues for really the need of having an estate planning attorney, working with the estate planning attorney to make sure that your wishes are implemented in the real world through your estate plan. Finally, there's no time in this webinar here, but there are various federal and state criminal and privacy laws that can apply to digital assets. So the sharing of username and passwords, et cetera. So again, there's a number of legal issues here that complicate planning for digital assets to be aware of. So to summarize, right, when I say digital assets present unique estate planning challenges, I mean they are difficult to identify. Right? They don't leave a paper trail. They can be difficult to access, and they really present some very interesting legal issues here. Okay, so I hope I've convinced you here of the importance of planning for these assets. I'm going to now talk about how these assets fit into a traditional estate plan. So a digital estate plan is mostly part of a traditional estate plan. Let's first recognize, digital estate plan. Sometimes it's called a digital will. These are synonymous. But this plan is not separate from, it is part of an overall estate plan, right? So if the overall estate plan includes these traditional estate planning documents like a will substitutes, by this I mean beneficiary designations or titling on accounts. Perhaps it includes trusts, powers of attorney. Your digital estate plan will fall mostly within your traditional estate plan, with some additions. And the additions here I'm referring to are really those digital tools. So you'd augment traditional estate plan with digital tools for the custodians for whom this makes sense, be it, I have some examples later, but Google, Facebook, Apple, they have some very flexible and robust digital tools that you can use. So your digital estate plan is your estate plan. If you don't have one, what can you do? What are some concrete steps that you can take to create a plan? So I'm going to go through sort of a four-step process here, at least that will get you started in putting together your digital estate plan. And again, let me repeat, if you have an estate planning attorney, that's the starting point, right? These are subject matter experts. Ideally, they have some detailed knowledge of the state law that's involved with the sharing of information, the transferring of digital assets, et cetera. But nevertheless, these four steps I'm going to outline, I think would be useful most for people who've not done an estate plan yet, or if your estate plan does not include your digital assets. If you follow these steps, you will be sort of well prepared to have a detailed conversation with your estate planning attorney at step 4, which is formalizing that estate plan. I'm going to go through these steps in order here. The first step is know what you own. Create an inventory. If you attended my previous webinar on the letter of instruction, this is a similar topic area right here. So to make things easier for your personal representative, your trustees, you should have a place where you have laid out what you own, and including things like usernames, perhaps passwords, so that when that trusted fiduciary is putting together the estate, trying to understand everything, they're not sleuthing and sort of putting together clues to try to put the pieces of the puzzle together. You want to create a list of your digital assets, and just here are some examples, and some factors to consider about what form that inventory might take. Can you grant access to other people, either now or in the future? Can you easily update this inventory over time? And whether to include passwords and other sensitive access information. This is probably the most difficult part of the process. People find it a bit daunting. And the problem I think I see is that people do not update this over time. Whatever form this list may take, it should be something that you are easily able to come back to over time and build out as your digital assets grow. And there are several forms that this inventory might take. I've listed just a few of these here. There's a paper list. I have a lot of clients who manage their digital assets with a notebook. There are advantages to this, right? If you lock that notebook in a safe at the house, it is unlikely that somebody is going to get into there and steal all of your valuable information. There are serious disadvantages with using paper, however, right? So one of those issues we find is that people don't update this list over time. It's difficult if you are out and one of your custodians here requires you to change your password. You may change it at your office or while you're on vacation, but you have to remember to go and update that list that's in the safe at the house. That can be difficult. The other major issue, I would say, is that when people use paper lists to track this information and to notate their passwords, they're often not creating passwords that would be as complex if they were using a computer to do it. So with a computer, you could instruct it to create a 32-character alphanumeric password. When people write down their passwords on lists, I often see duplicate passwords and sort of very simple passwords. And so you have to be aware of those limitations. If you're starting from scratch, you might consider a pre-built template. And so if you just go to your internet browser and search for a digital asset inventory, you'll find lots of examples of how people have organized their digital assets. This is one I really liked. So the Society of Trust and Estate Practitioners, or STEPS, inventory for digital assets and digital devices. I think it's well laid out. I think it sort of separates assets by type and has a section just for digital devices, which is really smart, right? If you weren't around, how would somebody access your computer or your phone, right? Another form of the inventory here would be a password manager. Password managers are pretty popular these days as a means of managing our access to various websites and services. Some of the big ones would include 1Password, LastPass, NordPass, RoboForm. There are real advantages to using these systems. People are more likely to keep their access information up to date. For the ones that I'm aware of, for example, they actually have browser extensions. And so in real time, as you are changing password or as you are adding a new username and password, a new digital asset to your inventory, it will prompt you to create a complex password and to add it to your secure vault. There are risks with these things too, right? They can be hacked. The information, even though it's encrypted, is still outside of your immediate control. But as far as sharing goes, it also has some particularly interesting aspects. So one thing that these programs will sometimes allow is to allow users to share access with trusted persons. Another thing I came across while researching this topic is that some of these services actually allow for access in case of an emergency. So in case of death or disability, you could hand over those credentials to a trusted person. You know, they would need to identify themselves and provide a death certificate, perhaps. But that's a really interesting way, perhaps, of transferring those digital assets to somebody in the future when you need to. And finally, very briefly, there are professional digital asset inventory vaults. So companies that are coming here to address, I think, a really important need, which is, well, how do I manage this? This is difficult, right? If I'm keeping a list or I have a password manager and I need to update these over time. So there are third parties here which are offering to manage the access information, to share that information under certain circumstances, to be a sort of safe repository for other estate planning documents, wills, powers of attorney, et cetera. To my knowledge, we don't have any experience with working with any of these companies. So this is just some examples of what I was able to find through some research, but important to be aware of. I think these will sort of grow in importance over time as people have more digital assets to manage and as this becomes more difficult to do over time. The second step here is going through each of your digital assets and deciding how you want them to be managed, right? And I think fundamentally there may be three things to be aware of. You could think about preserving an asset, transferring an asset, or deleting it. The first place to go should be these digital tools, right? Because if we think back to the legal regimen here, this has the highest priority. So if you have a digital tool, if your custodian offers a digital tool, and you have chosen to subscribe to that tool, that is going to most likely govern how that assets are disposed of upon your death or disability. So I point out sort of three of the largest ones here. Facebook's memorialization feature, I mentioned this earlier. Google has what's called an inactive account manager. This allows you to give users the option to choose who to share information with. That information could be email, calendar, contacts, or photos in the event of death. And Apple's, this is really sort of a brand new tool for theirs called Digital Legacy Program. This lets users transfer digital data to family or friends in the event of death. And you sort of set up legacy contacts, up to 5 legacy contacts that get their own secure key. And upon an emergency, a triggering event, those people are able to access the data that you've chosen in advance. Step number 3 is choose your digital asset fiduciary. So this is the trusted person who's going to be named in a will or in a trust to manage your digital asset estate. It should be a trusted friend or family member who, very importantly, has the technical wherewithal to perform the role. You may have a favorite sibling and they are extremely trustworthy and extremely loyal, but if they can't access their email account easily, or they're constantly creating new passwords because they don't have a way of storing them or they can't remember them, that person may not be a good fit for this role, right? Make sure that whoever you choose understands the role and they accept it. And finally, on some level, they will have to have access to your important information right now or in the future to carry out those functions. Beginning with that inventory list, think about whether and how to share access information. And again, here, the issue with a lot of these assets is you may say in a will, I grant my brother access to my Google Photos collection. If they can't get into that collection, or if Google will not recognize that instruction, your estate plan does not work as you expected. And the fourth step here is formalize your plan, right? So after you've organized all the information, which again, I think is perhaps the hardest part of this process, it has to be formalized. And so there will be estate planning documents that if you've not yet drafted them, will have to include specific language, or if you have an estate plan, you're going to amend those documents to make sure that they include instructions for digital assets. So really every will, trust, if your estate plan uses trusts, and power of attorney should include rules about access to digital assets. I pointed out a few times in this webinar where I think the law is very, very tricky here. And so you really need to work with a qualified estate planning attorney to ensure that your plan works as expected, right? So that there's no daylight between the instructions you have on a piece of paper and what's going to happen and in terms of execution in the real world. And finally, update your plan regularly. This is true for estate planning in general, but with digital assets, it's likely that inventory is changing a lot more rapidly than tangible property, right? People buy a home and they stay in it an average of 7 years. People buy a car, they'll keep it for years. In my experience, people will choose a bank to work with, and the money stays in that bank for a very long time. But the digital assets we use and the way we access those assets are changing very rapidly. So sort of make this part of your plan to update this at least every other year, that inventory, that access information, so that it's relevant, right? So wrapping this all up here, in terms of getting your digital asset house in order, I argue that planning for digital assets is essential. There are issues around planning these assets, identifying those assets, accessing those assets, and a slew of legal issues that arise when trying to grant access or transfer a property right interest in a digital asset. Remember, your estate plan, your digital estate plan is your estate plan. There's no distinction between the two. You want to treat those digital assets, or at least those digital assets, with very high sentimental value, right? With the same seriousness as you would treat other tangible property. And consider a process that is this process or similar to this process to organize your digital assets, to plan for the disposition of those assets in the future, to put together your team, that digital fiduciary or digital executor, and to formalize that plan with the help of an attorney, right? You wouldn't write your own trust or power of attorney, and you shouldn't make a digital estate plan without the help of a professional. Thank you very much. We are Sensible Financial Planning, and I'm Frank Napolitano, and here's my contact information. This is our website. We have offices in Massachusetts and California, and links to our social media are here. We do these webinar series monthly, and so keep an eye out for our July webinar. And thank you very much. We have hopefully a few minutes here for some Q&A, and I will do my best to answer your questions. Thank you.
Okay, Frank, so we have one question, and it is, how does one address third source verification of passwords in an estate plan?
How do I want to address one more time? Third source?
Mm-hmm.
I don't know.
Oh, so like a code to your phone or email.
Okay, yeah, so multi-factor authentication. That's a good question. There will be so many different ways of addressing this depending on the custodian, right? In some cases, it is, think about access that's tied to a handheld device, a phone. Well, if you don't provide instructions on how to access your phone, if you weren't able to do so, there may be no way to access your digital assets, right? Which is why if you're planning on these things, if there are digital tools, for example, that exist that allow you to bypass the authentication process, or at least the direct users authentication process, those digital tools are probably going to be a much better way of transferring or even destroying property than simply trying to give somebody your login credentials. But I admit there's going to be a mix of access issues here, depending on the custodians and depending on how people access those assets now and in the future.
Next question is, what in your experience are the most common digital assets that one should initially look at for the estate plan? A list on how to start would seem helpful.
I'm sorry, the second half of the question?
Sure. A list on how to start would seem helpful.
Sure. So honestly, I think if as a way of organizing this, right, because getting organized is probably the most difficult part of this process, thinking about what to do with assets. I think people have sort of intuitive sense of, oh, my photo and video collection, I want that to go to my surviving spouse, or my music collection, et cetera. The place to start, honestly, the STEP template there, I thought was really excellent. Let me open that up again and just put that on the page here. So if you're looking for an organizing principle, this is a pretty good place to start. Okay, and I wouldn't get hung up on trying to get everything done in one pass or in even one weekend. But if you sort of think about, and the assets here, they divided among financial information, social media accounts, documents, and et cetera. I think that's a great place to start the organizational process. If you don't get everything, don't worry. It's probably impossible to make a list of every single website that you have a digital asset in a username and password. But this resource, I think, was pretty good at sort of focusing on drilling down the most important assets and sort of getting the process started.
Okay. The next question is, are there digital assets that by design cannot be passed on? I'm thinking of my Kindle books. I think they are merely licensed for my use, but I don't own them.
Right. So that's a good point, right? You may have. I digitized most of my library years ago, and most of my books now are on Kindle. And I think if you're legally speak more generally here, I think you're true that you cannot simply transfer ownership of those Kindle books to somebody else. But you could gift somebody your Kindle, right? Your physical device. There are going to be situations where what you want to do and what the law says you can do are going to be in conflict. And here I would just say, be careful. There's a bit of a legal quagmire here, and the authority to go to for this is the estate planning attorney. You will make her or his job a lot easier if you've organized everything, you thought about this in advance, and you sort of put together your list of your wishes. I want to transfer my digital book library, or I want to transfer my music library. What can I do within the confines of Massachusetts state law or New Jersey state law, etc.
Okay, that's all we had for questions. Oh, I think there's a couple more. How does a digital asset provider know when a user had died? If a trusted person has access to a descendant's password manager, does that allow the trusted person to archive data or make account changes? In that scenario, does the trusted person have a responsibility to notify the service provider of the user's death?
Yeah, so this gets very complicated. So the terms of service, I think back to the Apple one that I pulled up, right? So they specifically say, unless you use our digital tool, or unless there is some law that requires us to give up this information, the information is non-transferable and essentially will be deleted upon your death. If you go through your list, and again, I think the first place to go to, that your estate planning attorney may disagree, the first place to go to is that digital tool, because it is the most efficient way to transfer or otherwise dispose of digital assets. It's in the situations where those don't exist, where those tools don't address what you're trying to accomplish, where we run into problems, and where, at least I know, some estate planning attorneys have said, look, the way to accomplish what you're trying to do is by often breaking terms of service and sharing usernames and passwords. But again, you have to be careful. You almost certainly will be breaking terms of service. That person could be breaking state or federal privacy laws by impersonating somebody. So tread carefully, begin with your preferred estate plan, your preferred rules around what would be transferred, what would be deleted, what would be maintained. And then again, working with an attorney, you're going to figure out what is the best and sort of legal way to accomplish those goals.
Okay, the next question is, you mentioned a digital fiduciary and a digital executor. Does the digital fiduciary role cease when the client passes, as with a power of attorney? Might a prospective executor for someone else's estate consider asking that person to name a digital executor as well? How would the executor interact with the digital executor? How would a court view these roles?
Those are a bunch of complex questions.
Yes.
I'm afraid I don't know, and I know enough to know that it's complex. So I will leave that one to the attorneys. I'm sorry.
And it looks like that's all we have for questions.
Excellent. Well, thank you, everybody. I hope this was helpful. It's a dense topic. As I was putting it together, I was really surprised how much more information was there than I thought there would be when I was putting together this webinar. So I know I'll be doing more sort of writing and presenting on this in the future, because it's a really interesting topic and really interesting questions here today. So
Right, sorry, one more question just came in. Can you comment on the potential issues of not identifying an individual's death? I see examples in Facebook where this does not happen.
A comment on not identifying the individual's death.
Right.
Okay, so I think you mean by the question, if you do not sort of let Facebook know, so now this is the survivors, they don't let Facebook know that their parent or their aunt or something died. Again, I think you'd be in violations of their terms of service by accessing their account after the fact, right? Because their terms of service are likely to say something like the information is non-transferable. So this is where planning is essential, right? All of us here, most of us here in this webinar, I'm assuming, have a Facebook account. I did not take advantage of their memorialization feature before preparing for this webinar. And now I've done it. And so I would say, plan in advance in ways you can't anticipate every possible change or every possible change in circumstances, but plan in ways that will make the decisions that your survivors and the lives of your survivors easier and sort of by reducing friction.
Okay. That's the last question.
Excellent. Well, thank you all very much. And I look forward to seeing you in one of our future webinar series. Have a great afternoon.